Court of Appeals Division 1 is now in session.
Thanks. Please be seated. Good morning. We're here for oral argument in MH220992, which is in re MH22 006-353. As you know, we record and live stream these proceedings, so when you first stand up, would you please state your name and your client's name? You'll each have 20 minutes per side. You're not required to take all that time. We do require, though, that you keep track of your own time from the clocks there, and if you want to reserve any time for rebuttal, then that's up to you. And keep in mind, before you start, that we have studied the briefing, the record, and we've discussed your case in conference this morning. And with that, Mr. Shipman.
Good morning. Robert Shipman with the Office of the Legal Defender on behalf of Mr. Lambeth. May it please the Court, obviously I represent an appellant here. I would like to reserve 2 minutes for rebuttal. In our case, the treatment order should be vacated because the appellant in this case could not be treated as an inpatient at the hospital, and there also was not a written treatment plan for outpatient treatment presented to the court. Here, I would say it's going to be strict compliance here because it's a legal issue. There haven't been any disputes about the facts. The issue that I wrote the appeal on was claiming that the statutes weren't strictly complied with. There just weren't facts that were admitted that would support a finding that there could be this inpatient treatment and this outpatient treatment that would be available for the appellant.
Mr. Shipman, can you do us all a favor and just kind of help walk us through the mechanics of what happens below and why there are cases like this that come up and you say, has this never come up before? I mean, there are certainly people that go through mental health court who are awaiting criminal charges in the jail. Why is this a unique situation, and what, practically speaking, especially in light of 36540 that says that if the court makes these findings, which, like you say, there's no dispute about that, then they shall order the patient to, and they've got a couple of choices. So in a patient like this, what is the court to do with that mandate from the statute and the narrow 1, 2, 3s of what they can do in that order that they're told they have to issue?
Okay. In the first part, to answer that question, there's a few, I'd call them concessions, in that, one, I'm not arguing, I'd concede there are people in the jail that may need mental health treatment. I don't think there's any debate about that. It does come up from time to time. People need treatment. Also, in this case, is whether or not appellant needed treatment. That really wasn't in that much dispute below. The appeal here and the issue here is that the argument that has to be strict compliance. And the issue there is, if this is a person that's going to receive treatment and they're not in the jail, they would go right into Valley-Wise
Sure.
or to treatment facility. If they're in the jail, the question becomes, can the jail do that? My position is...
Can the jail... Oh, go ahead.
Is that really the question? Can the jail do that? Do what?
Yeah.
Provide
Exactly.
the inpatient treatment? Or can the court order remain and the jail provide mental health treatment pursuant to some other mechanism?
I guess there might be two issues there. Obviously, in the jail, I think there is an issue whether, pursuant to this order, the jail could use this. My position is that the jail couldn't. I do think there's potentially a fix for that if the legislature wants to add the jail as an authorized provider, or the Department of Health Services wants to work with the jail and approve them.
So if we agree with you that the jail cannot provide mental health services under this order, does it invalidate this order?
On this one, I submitted that it does, and that Valley-Wise said they were not going to admit the appellant, and they didn't have necessarily plans to do that, potentially because it's indefinite. They don't know when or if he was ever going to get out of custody. For strict compliance, my position is that there has to be something in place where the court can say, we've been presented with something where not only can I enter this order because I've made a finding this person is a danger to self, danger to others, or persistently acutely disabled, but also I've been presented something where when I enter this order, I know they're going to get treatment for this.
But doesn't that presuppose that they're not in custody? I mean, if, say, this patient were released from custody, wouldn't it benefit everyone if this order were to remain in place so that it could take effect upon his release from custody?
It potentially could, but I think it gets maybe a little bit to the intent of what the jail was doing here, and that they could have done that if it reaches a point where this person is going to be released from custody. If it's coming to a point where there's a settlement, there's going to be, for instance, a sentencing date or some indication there's going to be a dismissal.
But what in the statute and in the procedure requires them to wait until there is a release from custody before they can get a court-ordered treatment plan in place? He had a previous one while he was incarcerated. This is another court-ordered treatment plan that basically has no effect unless and until he's released from custody. Isn't that the case?
It is. I still think it has to be strict compliance with the statutes, and to do it prospectively, it's possible he's out in 6 months, a year and a half. I think we have to be very careful, especially some of the cases cite the liberty interest here, to prevent a situation where courts are just entering prospective orders that may be met at some point in the future and may not be, because that's where this one is. We don't know, assuming the jail isn't trying to use that, and I'm not going to speculate whether they are or not, but assuming that this order is not something the jail can use to force medicate the appellate in this case, to me it's just a speculative order that's just going to sit there, and it may or may not come to fruition at some point in the future. And I think the court should be deterred from just entering these orders unless, like I said, if it's imminent. And I understand with the court's concern that there may be an issue where this person does need treatment and maybe it needs to be inpatient.
But there too, you're stating a different problem that's before us, and that is if the jail went to use this order to medicate him, you may have, that patient may have a right to say, look, you have a valid court order, but you can't use it in the way you are, or I guess I'm having a problem. We're not here on a cells issue. Nobody's saying that somehow the jail doesn't have authority to inject him, but they are against his will. The court is required to issue an order. I don't see in any of this briefing a way out of 36540, which says if you're making these findings, which again, no one's disputing that those findings were made. That's not what you're saying in your briefing. You're just saying that there's some sort of impossibility for carrying out this order. But the order lasts for 365 days, and certainly 36540.01 contemplates that these orders can be amended over time because patients have fluid situations. So why are we concerned here with this can't be done today, but it may be able to be done tomorrow, which could be said of many mental health patients who are under a COT?
Well, I would submit because the court didn't have any evidence that was what could have happened. The stipulation that was entered was that value-wise, the treatment agency was definitely not going to admit.
On that day, on the day of the hearing, you both say, and it was borne out by the fact that they wouldn't even keep him during the 6-day period to evaluate him. They weren't going to keep him then. But what changes from him being, the charges being dropped tomorrow, from value-wise getting a new policy in 7 days that says, okay, now we do have the security and we have the wherewithal. Why should someone who's in need and who otherwise qualifies under 540 not be able to get an order if they otherwise qualify under 540, even if it may not be able to be carried out that day?
I would submit because it still has to be strict compliance. They can repetition him. If 7 days later, a month later, something changes, they can go through the same process if they then have value-wise showing up saying we can provide the inpatient treatment. My issue with the treatment order here was that at the date of the hearing, value-wise said we can't admit them. We don't have any plans in the future when we think we can admit them. And that's all that was in the record about inpatient treatment. So
but how does the court comply with 540 if they can't, if under your scenario they can't make an inpatient order or an outpatient order, and yet they are compelled to do that by the statute? What could the Superior Court do in that circumstances where the argument is impossibility as to both treatment plans?
I think they would have to find that the statute is not met until they're submitted with value-wise able to say this is when we can treat this person, we're going to be able to do this, or an outpatient treatment plan where they've coordinated it and spelled out this is the treatment we can provide for this person. I would think the Superior Court at that point would have to say the statute hasn't been met. We have to deny the petition. If you come back in a week or two or a month or when you know this person's going to be released from custody and Valleywise can show up and say, you know what, we'll admit this person, then I think it's a different situation. But there's not a bar to repetitioning somebody in appellant's shoes here. And I'd submit the proper procedures to say, well, at this point, the statute's not complied with. I can't enter that order. There are liberty interests here, and let it go to another day.
Well, let's talk about that. So we have a mental health issue that's been conceded that would require treatment. Up to this point, we're all on the same page, right?
Yes, there were no facts that were in dispute about whether mental health treatment may have been needed here.
Okay. So doesn't that color the liberty interest? I mean, if we're talking just about providers, is that really a liberty interest?
I would submit there's still some liberty interest there, and that you're...
To choose your provider?
Well, I think the court would still have to have some information on what's going to be provided, because, for instance, pursuant to these orders, people are injected with medication they don't want to take. They could be in a facility where it's a lockdown facility, where they're restrained. So I would think, I agree with you, the liberty interest definitely goes to the first part of that, but I still think there's some liberty interest to protect in the second portion, and saying, we're not just going to give kind of a blanket order when this person may be, like I said, forced to take medication they don't want. They could be restrained, that there's still some liberty to protect there as well, to say, we want to see a plan as to what the plan of action is. If I give, I work for the court, I'm going to give authority for you all to do this. I would submit that those details need to be there.
So how many vendors are licensed by the state other than Valleywise?
That I don't know an exact number. I do know it.
If one of them was willing, this would have been an appropriate path. I guess my question is, what if the vendor is unwilling? It seems like you have no option. The government has no path forward to seek mental health, inpatient mental health services, or I guess that's what we're talking about here. But is there a path if at the very end the provider just says no? Is there a path forward for the government to get that relief?
Well, I would say in two ways. One, here, I think dealing with the jail, there's a potential fix through the legislature, Department of Health Services, to get the jail approved if that's what they want to do. I think there's a way to do that through the system to get that corrected. So situations like this are easier. I don't have an argument here if the jail is an authorized provider. The treatment order goes in, and if they're going to force medicate my client, they're going to do it. And then as far as the providers, I still think some of that, has to be in the government again, and that, it's not criminal in nature here, that it's therapeutic is the game for mental health treatment. And, it's not necessarily incumbent on somebody like my client to find a provider that can do it. If the government wants to force them to do it, there may be talk to different providers. Maybe they need to get new contracts. I know I'm speculating a little bit there, but I do think there's still something that the government could do that shouldn't necessarily put it on somebody like the client that I represent in this case.
Isn't the court authorized to amend that order?
If it went back, I would think the court would have authority to amend it. I don't know if it would have to be remanded or...
So let's talk hypothetically here. You're presented with the facts of this case, and you're the court. And nobody disputes that your client is in need of court-ordered treatment. That's undisputed here, correct?
Yes.
So as the court, what are you going to do when you're presented with a shall, which means you must, and 3 options? What was the court to do in this circumstance?
Well, I still submit that the 3 options weren't completely met. That's the issue here, that I do understand the court's position. I do think this is a really tough case because of the facts.
Well, you keep talking about strict compliance, that the court has to strictly comply. And we talk about a liberty interest, and we talk about all of these things, but the court strictly must order one of 3 options, which the court did here. Your argument is that because Valleywise wouldn't accept him on that day, that the entire procedure and order is invalid. Is that what I'm hearing?
Well, that and the combination of the fact they said they didn't have any intent or plan to accept him in the future, that it was left speculative.
So it's speculative whether or not they'll be able to treat him in the future. It's speculative whether he is ever going to get out of custody. All of these things are very speculative. But if the court can amend the order upon his release to identify the treatment provider, would that be appropriate?
I still think it's an invalid order, and that gets back to what I'm saying. They can petition him upon release at that point when all of this is in place. The objection we have is based on what's been presented so far. The second part of it, it's A3, where it talks about the inpatient treatment, and it has to be in a mental health treatment facility. It can be set up through the Veterans Administration. Could also be in the state hospital, or there's a provision where it could be a private provider, but there has to be some sort of agreement. And that, in this case, it wasn't met. There's no evidence at all upon which the court could say that that was available. And
Will the state hospital take someone like your client in these circumstances?
That, I'd say I don't know for a few reasons.
Pre-conviction, he's not SVP, he's not convicted, he's not subject to a court order placing him at ASH. Does ASH typically take these kinds of patients?
I think it's unlikely, especially pre-conviction. Another issue, and I'm not that well versed in it, I do know ASH, I think, takes more people from counties other than Maricopa County. I don't know how that, I know there's some sort of relationship there where I don't remember exactly the specifics of it. So I would think it would probably be unlikely is what I would go with. I don't want to say 100%.
Did you want to be heard at all in addition on the waiver argument?
I will briefly, yes, since I have time. I think Mr. Brown did raise these issues. He filed the motion to dismiss where he was saying that there wasn't a valid outpatient treatment plan. He did get into the generic nature of the letter of intent to treat. He did point out the same issues that I'm raising, that there wasn't an inpatient facility that was at that time saying they could accept the appellant. He also secured the stipulations at the day of the hearing. The motion to dismiss was prior. That was the day before. And then at the hearing, he secured the stipulations that, they agree that Valleywise wasn't going to accept them that day. And then he did call Dr. Stephen Lopez from La Frontera to get into a little bit about the outpatient treatment plan. So the combination of the motion to dismiss, some of the evidence Mr. Brown presented, I would submit clearly was an objection to this issue and preserved it for appeal.
Thank you.
Okay. If there are any questions right now, I'll reserve. I've got about 2 minutes and 40 seconds. I'll reserve that. So,
Thank you.
Thank you.
When you're ready.
Good morning, and may it please the court. My name is Joe Branco from the Maricopa County Attorney's Office, here on behalf of the appellee petitioner. There's been a lot of discussion about strict compliance, but there hasn't been a discussion either in the briefing or below or today about what exactly wasn't strictly complied with. There's a shall in that statute in 36-540. The court was required to enter this order when it was determined that the patient is very sick and needs help. Whether or not that can be completely effective, that order, that's speculative. But it's not speculative that the statutory test was met. Additionally,
I think Mr. Shipman's point is that the statute is met. The court's trying to comply with the statute, and yet if you define inpatient treatment as they do in 540A3, it really hasn't, because he hasn't ordered inpatient treatment, because inpatient treatment by definition does not include treatment that occurs in a Maricopa County jail because they're not licensed.
correct, but there's nothing in this record that indicates that treatment is taking place in the Maricopa County Jail. This is no different. I mean, let's imagine we've seen an explosion in mental health cases over the last few years. I think the court can take judicial notice of that. What happens when we run out of beds? We stop issuing the orders while we're trying to build more hospitals and issue more beds? We're just going to leave people on the streets
But I
like
think
this?
his point is that if you're going to say that an inpatient, if the court is saying that an inpatient treatment is not one of the things listed in A3, but is instead, a bed in Joe's apartment retreat that he's calling a therapeutic bed, and the court orders that, and it doesn't comply with what the definition of inpatient treatment is, then is that a valid order?
No, and I think that's at least 2 steps removed from the order that we have here. The order we have here is proper. It is for combined inpatient and outpatient treatment. The fact that it's not effective as of the date it was issued, or perhaps even today, doesn't render the order itself invalid. Nothing in the statutory scheme wasn't complied with.
When you look at the last part of A3, it says, in a private hospital, and then it goes on to say, if the private hospital agrees. So here, has the private hospital actually agreed to be the outpatient or the inpatient facility? And if the private hospital does not agree, how do we assess that? What do we do with that?
I think that there would need to be a better record for this court to be able to assess that. I don't know, though, that the stipulation in this case was very narrow. There was no mention of any intent. That word's been used in the briefing in here today. That isn't in the stipulation. And again, it speaks simply to the speculative nature that the hospital would not agree if certain conditions were met. I just think that this isn't the right case, and the mental health court isn't the proper forum to make these types of decisions about what's going to happen in someone's criminal case that's then going to affect the willingness of the provider to provide inpatient care.
On the day the order was issued, the court was presented with 3 options. We look under 3 and it says the private hospital, if they agree. I think the record is clear they did not agree to take him for inpatient purposes on that day due to security concerns. So because they did not agree on the day the order was issued, does that invalidate the order?
I don't think so, because
Why not?
Because there's no temporal constraint on written into that statute there.
True, but if you agree, you say yes. Here they said no. So how do we get over that?
Again, I don't know that they've said no for all circumstances. They've said no as of that time. I guess that's the problem that I'm having here, is that we don't have a no, we have a maybe. And I don't think that is the type of I don't think that that's the type of refusal that the statute considers. I also don't think that this issue was raised below or in the briefing in terms of the hospital's refusal. There just isn't enough in the record to understand the hospital's concerns. I think that that the record just simply doesn't support that argument at this point.
Can I ask you, just practically speaking, if we were to say that the inpatient order was invalid, but left in place the outpatient order, what practically does that do for this patient, for the court below? If we're invalidating one but not both, either side, what does that look like below?
I'm sorry, when you say what does that look like below?
So say we say that, look, the court should not have entered an inpatient treatment order. The outpatient treatment order was just fine, but because of this issue with Valleywise saying no, we invalidate the inpatient order. Or we say, no, the inpatient order is fine, but they didn't strictly comply with all of the requirements for the outpatient order, and so we're going to say that that's not valid. The end. What does that do procedurally below? Are there any consequences of doing either of those things that you think we should be aware of as far as where it places the patient, where it places the court below?
Under the circumstances of this case, I don't know. because the patient is, right, for the time being, in pretrial detention. And that's the whole basis of the appeal, of course, is that it's not an effective order as of this date. So practically speaking, I simply don't know if this court was to split the issue or split the two. I don't know what practical impact that would have.
Or whether 540.01 and the amendment provisions in it would give the court, would the court have authority if we invalidated one or the other, but circumstances change? Could the court sua sponte, as the statute contemplates, go back in and add an inpatient order, add an outpatient order if we've evaluated it? Or do they have to petition the patient again?
I don't think they'd have to petition the patient again. I think that the court has continuing jurisdiction, and I believe in this case there have been reports in the meantime while this appeal has gone up. I could be having my cases mixed up. But the court has continuing jurisdiction and the ability to adapt as time goes on. With that said, of course, I don't think there's any need for this court to remove either component. One other thing that I heard that I want to correct is the lack of an outpatient treatment plan. That's incorrect. There is one. It's in IR20, and it looks like it's a pretty well-established form. There are check boxes. It talks about what outpatient treatment components are part of the plan. So the letter of intent addressing this particular patient and his circumstances in the jail is in addition to that plan.
But Mr. Branco, when I read this IR20, the outpatient treatment plan, I have no idea from looking at this that this gentleman is housed in the Maricopa County Jail. I have no idea who would actually be providing the medication to this patient, and aren't those required under the statute that I know the address that he currently is living in and who would actually be providing treatment? Because the record seems pretty clear that it's not going to be La Frontera, waltzing into the jail with a syringe. That's not happening. So when I read this court order, as the Superior Court Commissioner in this case, I wouldn't know but for this briefing that this was someone who's incarcerated and who's not going to be given medication directly from the outpatient treatment provider. So isn't it deficient on its face?
I don't think it's deficient on its face, because when you take the combined outpatient treatment plan and the letter that discusses La Frontera, Arizona's relationship with the jail, I think those two things make clear, right, well, again, part of what we're talking about, the circumstances of someone in jail and the security concerns that jails present as well. Right? It's not just...
Is the treatment letter considered a part of the outpatient treatment plan?
I believe they were filed together, yes.
But is it considered part of it? Whether they're filed on the same date or together or in conjunction with each other, but is the court bound to consider this treatment letter a part of an outpatient treatment plan?
I don't.
Because without it, tethered, it may mean one thing. Untethered, it may mean something else. I'm just looking, is there authority that the treatment letter somehow has to be read as part of the outpatient treatment plan?
I don't know, and that's not in the record. And that's part of the problem that I'm having with this appeal, is that we're getting awfully speculative and getting very far from the very, very narrow issues that were in the record below. And I think that in particular, when this court and other appellate courts are considering mental health cases, the fast-moving, statutorily mandated, expedited cases, high volume, as I said, the explosive growth of these cases over the last few years, I think that we all, I'm not a mental health attorney. I'm not in the trenches every day litigating these cases. So that's why I frequently answer, I don't know. I think that we've all, for myself, when I do these appeals, I've got to be very careful about how far I can go with these.
Is this really the proper vehicle to get somebody in jail, mental health treatment and services? What gets me is we talk about the reason that they petitioned for court-ordered treatment is because he was receiving antipsychotic injections while in the jail based on a previous order. Now, I don't know that he actually could have been given antipsychotic medication under the previous order, because as we have all come to realize, the jail is not an authorized provider. So I'm wondering if this is even the proper vehicle. We talk about sales hearings and things of that nature, and just practically, isn't that the better way to go?
I think that this is the proper vehicle because the statutory test was met. I don't think it's a proper vehicle for questioning what's going on in the jail and whether or not another client of mine has potentially exceeded its authority in any way over the last couple of years. And that's, again, I think that's where the Superior Court was very cautious in terms of what it was, willing to consider in its limited purview. So no, this is not the most effective way that we could all imagine. I mean, these are the tools that are available, though.
Do you think maybe the best fix would be to get the jails authorized as providers under Title 36 for the people that are incarcerated? And that fix, I know, is with the legislature.
From your lips to the legislature's ears.
Okay.
I think that would be very helpful to have, and also just to be clear in terms of who the authority is in there. In Maricopa County, it's Correctional Health Services, which is run by the county, rather than the jail, which is run by the sheriff, in terms of the provision of medical services. Just so we're all on the same track with that. But that would be, I think, a way of making sure that orders like this are more effective than they currently are.
So with this order and the inpatient treatment part, let's take that up. Because the provider identified in the order is not willing to take the patient on that day, does that invalidate the order? And your answer is no.
Correct.
What should the court do to address that circumstance? Because entering an order for inpatient treatment without identifying a provider is not all that helpful.
I think the court did identify, if I recall correctly, and I apologize, I don't have it up, the court did identify the provider. It's simply that as of that time, the provider, right, wasn't, due to security concerns, wasn't taking the patient. And I have the stipulation up right now. When he came, he did not stay the day, as counsel said, but he remained there because of security concerns, and he would not be returning because of security concerns. I just think that's really thin in terms of what the hospital's intent is moving forward.
So it's your position that the hospital did not say, we will not agree to take this patient. It just said we have security concerns that need to be addressed.
My position is that's what the stipulation was, what I just read right now. And again, if there was anything further in the record about the hospital's position, I missed it.
If we take this out of the context of Maricopa County and put it in Apache County, where the providers are limited, there will often be times that there is no provider in that community that can provide services. What is a court to do? Because they shall enter the order.
I think they shall enter the order. I think that part of the problem that I'm having with this appeal is that it's reading into the statutory scheme this extra finding. 540 has subsections A through S. A, B, and C talk about things that need to be determined, things that need to be found. And the effectiveness of the order, or the potential effectiveness of the order, it just isn't in the statute. That's something the legislature could certainly add to it.
Or as another cause of action, an injunction to prevent the jail from providing, from forced medicating because they don't have the authority under the order. Or an order that says, Valley-wise, you have to take this patient. You have to figure out how to take this patient because there's an order that we're trying to effectuate. But you're saying in this process, the court did what it had to do under the statute, and the repercussions from that and how it's carried out are for different causes of action potentially.
At the risk of inviting my clients to get sued, yes. This simply isn't the forum to go that next step. With one exception, I apologize. One exception. I do think the court has continuing jurisdiction over, as we've discussed repeatedly today, over these orders. And so the court could determine, in many circumstances, right, to adopt something different or change the orders. But for the issue that we're talking about, it's out of bounds.
Okay.
And so we should just disregard the if the private provider agrees portion of this statute.
don't think that, so this was something I had trouble reading the statute on, because it's got 1, 2, or 3, right?
Right.
And the third one is where it says if the hospital agrees.
Right.
But the second
one doesn't.
one of the following, the second one doesn't.
Right. It's
So
interesting.
disregard that
I would say 3 just isn't applicable in this case.
for
2
strict
is.
compliance.
Correct.
It's weird to have
Because
the
it says-
definition
sorry.
come during the second part of the phrasing of inpatient treatment.
And I would also point out to the court that it says the court shall order the patient to undergo one of the following.
So let's say under this, we find that the address isn't sufficient in the outpatient treatment and invalidate that portion of the order, and we're left with just the inpatient portion of the treatment. Then are we in this catch-22 where 3 would apply?
So I'm sorry,
If
the
we invalidate
outpatient,
the
which part of the
outpatient.
address?
If we just invalidate the outpatient and what's left is just inpatient,
I
and
guess
3
I'm-
then comes into play.
I guess I'm having trouble understanding the basis for striking down the outpatient on the basis of the address.
Just a hypothetical.
I'm concerned about, I do want to note this, and I promise I will answer your question. I'm concerned about this because of what I said in the briefing, people with fluid housing situations. If we're going to get very technical on something like the address, I think that would have significant repercussions in the mental health courts. I also think this argument about the outpatient treatment plan was waived completely.
Isn't there a difference, though, between saying someone is homeless and saying someone's in the jail where there is an actual address? I mean, I understand what you're saying is that people have fluid situations, and not having an address can be a thing, certainly in this population, but this person has an address as of the date of the order.
I don't know that the jail would be considered the person's address.
Well, the jail is where the person is living. I assume that the inmate can receive mail at that address, and as long as it may take to get it to him, if someone addressed something to that inmate in that jail, he would receive that letter eventually.
Yes.
Okay.
I would note that the scheme doesn't say mailing address, and that's, I think, part of the
Well,
problem.
he's living there.
Yes, I understand, Your Honor.
In a
I-
place that has numbers and a street name, as opposed to the corner of.
Understood, Your Honor. I apologize.
No, you're fine.
And now, of course, I promised to answer your question and have forgotten it about, would 3 come into play if you struck down the inpatient provision?
I just don't understand how 3 is not mentioned in 2, has this private hospital agrees if it's strictly an inpatient submission. The whole thing seems a bit...
Wonky, I think, may be the word that
I
the court
like
is looking
that
for.
word. That was the one I was searching for.
I
Wonky.
think that it is a bit wonky.
And your position is they didn't necessarily not agree. They just said
No.
we can't agree under the. We could agree under certain conditions. You're flipping that.
Yes, I think they're saying not now, not never.
Yeah.
Additionally, I do want to, at the risk of poking the court about the waiver, I don't, as I said in the papers, I don't believe that the issue about the outpatient treatment plan was raised below. It was all part and parcel of the same issue about the effectiveness of the order. It didn't point out anything that the plan lacked. It was what the plan contained that they objected to below.
All right.
And with that,
Thank you.
I appreciate the time. Thank you.
Thank you, Mr. Branco. Mr. Shipman?
Okay, touch briefly on a few things. There's some discussion about this not being the proper vehicle, and that maybe captures the argument for my client better than anything, is that it's just not the proper vehicle to get this done. The jail is not licensed by either the statute, under the statute, or Department of Health Services to provide the inpatient care. It's something that could be done. Maybe it's a fix that needs to be done.
But if they never try to give him medication, it's kind of like if the tree falls and no one hears it. I mean, he has an order, but if nobody ever seeks to effectuate that order or tries to medicate him against his will, has anything really been done to him other than having a piece of paper out there that says they could, but they're not going to try because they see other legal issues or whatever the case is? No one's, and if at that time, couldn't you say, try to get an injunction that says this order does not allow you as a non-licensed entity under 540 to medicate him and take up your fight there?
Well, I would say maybe 2 points to that. One, again, I keep going back to the liberty interest. It's still somebody that's going to be ordered to get mental health treatment, and the statutes need to be strictly complied with before
But
the
you would
court can
agree
do
with me
that.
that his liberty interest under this order is not in jeopardy because he's already in jail. So that liberty interest would become in jeopardy when he's released from jail.
It potentially could.
So
But-
would that not be the time to challenge this order?
Well, for one, the appeal rights would probably have run at that point, so he probably wouldn't have the option to do it at that point.
Good point.
And I also, with it not being proper vehicle, I think the intent here is all three of the acquaintance witnesses were all from the jail. So I think on the surface, what the intent here was to get a treatment order. The jail was trying to get a treatment order. I submit that's not the proper way to do this. If it needs to be changed to the legislature, it needs to be changed with the Department of Health Services. It's definitely something that probably needs to be cleared up. I've conceded it. There are definitely people in the jail that likely do need mental health treatment. I can't come in here and say, oh, that should never happen, because there are definitely cases where it's going to be necessary. But I would submit that would be the way to do it. And other than that, I appreciate your time, and I'll conclude.
Thank you. Thank you both for your arguments. We'll take the matter under advisement and issue our decision in due course, and the court is adjourned.